Good morning. Thank you for joining us today for this CABE webinar, the subject of which is dealing with dangerous buildings from a legal and practical perspective. My name is Katie DiStefano. I'll be acting as moderator this morning and looking after any queries and questions that you may have. If you've got any questions, on your right hand side there's an admin panel at which you can send any questions over to us using this facility. I can see a few of you have already got what the class has raised hands, so if you've got any questions already, please feel free to pop those questions into the question box and we'll do our best throughout this morning to answer any questions either as we go along or we'll cover them off at the end. If you're on Twitter, you can join us with CABECPD as your hashtag. Your presenter today is Kevin Blunden, Deputy Chief Executive Technical, and he will be talking you through. So I'm now going to hand over to Kevin.
Good morning. There'll be a slight pause while your screens flick over from one of us to the other, so hopefully you can then still see a presentation in a reasonable sort of time frame. Let's just click through to where we already were. Okay, so we're going to start today by looking at dangerous structures and dangerous buildings and some of the practical aspects involved in dealing with them from the owner's side, looking at some of the insurance implications, and then looking at some of the implications for those who have to come through and then look at putting these properties right, whether that's somebody working within a local authority who have responsibility in relation to these sorts of buildings, or whether it's maybe somebody acting on behalf of the client or instructing a contractor to carry out your work that could be construed to be under emergency circumstances. So we'll be trying to look at the whole sort of remit of responsibility, if you like. And quite clearly the primary responsibility if a building falls into disrepair or becomes dangerous lives with the owner of the property. They have a responsibility in law to protect people, and under common law there are issues should something escape from a property and cause damage or injury, and that would include things like guttering falling off, slates falling off of roofs, would be covered by that in terms of liability for your neighbours and for visitors to the property. The local authorities do have a range of powers to deal with properties that are in a state of disrepair or have become or might be dangerous in the future, and that is a legal obligation on them to look at these things. They will take that duty very seriously, but it shouldn't be seen as a catch-all safety net for the householder. Ultimately, the main thrust of most local authority action is to try to get the owner by one means or another to actually put the work right themselves. And certainly from an owner's perspective, it will be more cost effective for them to actually engage a contractor and get work carried out themselves than allow the local authority to have to step in and do work in an emergency situation, which whilst they can't do things that are going to be too costly, they will recover reasonable costs, and anything done in a short-term emergency tends to be more expensive than if it's a bit of planned maintenance. So there are quite wide-ranging powers devolved to the local authority, and then it really depends on the actual individual local authority as to which section within that organisation actually deals with some of these things. And there are several powers within the Building Act and other legislation that deal with buildings that are in disrepair, buildings that are dilapidated, and buildings that are dangerous. And not all of those will fall into the building control sections. Some may well be dealt with through the planning process, and some may be dealt with through environmental health. And it really does vary from authority to authority depending on how their delegation of the responsibilities put on them in the legislation actually works. Obviously, the vast majority of properties will cover some form of insurance cover, and this is normally one of the first instances where we start to get outside bodies involved once something becomes dangerous. Property insurance will deal with things like the immediate impact, temporary works, putting the building right at the end of the day. It'll also deal with evacuating occupants and maybe finding them alternative accommodation. Clearly the emergency services may well be involved in the beginning of the incident, and then overall as well, there's an obligation to protect people in and around that building. And a lot of these things in terms of how dangerous structures are dealt with, once the initial response has been made, maybe by a local
Apologies to everybody for that slight problem. We now appear to be back online. Again, sorry for that. Kevin, could we ask you to pick up, unfortunately, I believe really it's going to be the slide where the car goes into the wall. If you could start from there, please. Thanks.
No, that's fine. As I say, apologies for something that obviously went wrong with the technology. Hopefully everything will run smoothly from now on. Yes, so if I pick up from where we were in terms of sort of early doors really, dealing with the insurance industry, obviously a good number of properties in the UK will have property insurance cover. And if that's the case, then when dealing with a dangerous structure from a surveyor or contractor's point of view, the first instance is going to be to talk to the insurers to try and establish what they can get operated, what they can work with in a relative short space of time. And it may well be that in the interim, if somebody's dealing from a local authority perspective with the dangerous building, that temporary works are put in place to protect the public, which might include closing footpaths, closing roads, and await the insurance and their designated contractors to actually carry out the work. That may also involve some of the coordination with the emergency services, if something's being done on an immediate basis, and it may also mean that the occupants of the building have to be relocated. Now, the insurance may well pick up the cost for that in some instances. If there isn't appropriate cover, then those dealing with the dangerous structure in the local authority may have to talk to housing departments, to social services, to see if temporary accommodation can be found for residents whilst the premises is put back into a safe situation. But as far as possible, it's usually preferable, unless there's an absolute emergency and an immediate danger, to put these things into the hands of the insurance company and let them get resolved that way. Okay, let's see if we can move on. So one of the big dilemmas when looking or called to a potentially dangerous situation is how dangerous is it actually likely to be? Is it just something that needs additional maintenance? Is it just a generally dilapidated building? Has it the potential to become dangerous in the not too distant future, or does it immediately need some action to be taken? And these will always be a judgment call based upon the individual circumstances that you may come across. And it can be quite difficult to make a decision and decide what's likely to happen. And then again, any action that's taken probably needs to be proportional to the potential danger. And it may well be that in some circumstances the danger may only affect the occupant of the property, and if they are fully aware of the situation, there may be little more that needs to be done immediately to protect the general public. But we have to consider the occasional user to the premises who isn't necessarily as aware of what might go wrong. So the question will be, is the situation dangerous? Do we actually need to just maybe monitor this over a period of time and encourage the owner to do something about it? And at some point, when does it become dangerous enough that we actually think the appropriate action to take is some immediate action to actually resolve the issue? And that's always going to be quite a difficult judgment call. Unfortunately, a lot of the time when dangerous structures are reported, it is a case that, here we go, this really doesn't want to work this morning, but quite often it can be difficult to establish what's actually going on. A lot of dangerous structures, for instance, will occur at high level, can occur in roofs, so it can be difficult to get to see what's actually going on. And in a surveyor's toolkit to try and establish what's happening with the condition of a building, obviously a decent set of binoculars will help. In extreme situations, a cherry picker or even using the fire service to gain access to high level may be the only option. There have been recent suggestions that using technology such as drones fitted with video cameras may be one way of viewing inaccessible parts of the building. The only difficulty with this is the experience shows that the majority of dangerous structures occur during inclement weather, particularly high winds, or during the hours of darkness. So actually things such as drones may not be as useful in those circumstances. Now, I know we had issues with sound which prompted a lot of questions, but there do seem to be quite a lot of questions popping through. So perhaps if we can try and address some of those as we go now.
Yeah,
Try and
hi
pick up
Kevin.
how we go.
A few questions
go.
coming in regarding reclaiming costs and whose responsibility it is, and instances where people have been taken to court. Are you able to address reclaiming costs?
Yes. In terms of reclaiming the cost for carrying out work in relation to a dangerous structure, there is provision within the legislation, because legislation places a responsibility on local authorities in relation to this. The first process is always to try and encourage the owners to actually try and do some of the work, and perhaps if I click onto the next slide whilst we're talking about this, it will start to make things a little bit clearer. So there's a raft of legislation that can be used to get matters put right, depending on what it is. Now, there's also the ability, if something is immediately dangerous, under Section 78 of the Building Act, for a local authority to move in and carry out emergency work. And this is where something is in imminent danger. The issue will always be that where work is being done in an emergency situation, or where the opportunity has been given to the owners, maybe orders have been served, notices have been served to get the owners to do the work, and they failed to do so, and therefore the local authority has to move in and do it. In those circumstances, the local authorities can reclaim the reasonable cost for doing that work. The problem tends to be then that once the matter's been made safe, there will usually be a debate about how much of the cost was reasonable and whether in fact the work needed to be done in the first place. So one of the key aspects of dealing with any premises that is dangerous or potentially dangerous is to make sure that there are full and detailed records of the condition before you actually start to do the work. Now that's going to be video record, it's going to be photographic records, it's going to be written records, because there will be a debate afterwards as to whether there was a need to carry out emergency work and whether the cost of the work was the minimum that it needed to be. And the balance will always need to be, do we move in and actually physically remove the danger from the building, in which case we may have to be looking at maybe removing tiles or slates from a roof, taking down the leaning chimney. We also then have to make sure that the building is still weathertight and secure. But is that the most economic approach, or do we simply just fence around the property and that potentially protects the public? So you can reclaim as a local authority your reasonable costs, but be aware, because it's going to be debated after the event, there needs to be a very good evidence trail of how dangerous it was and how necessary it was to carry out the work in the way it was done. Right, so there we go. I'm just looking at seeing what else we've got there in the way of questions. So we've got some issues in terms of can we go through the courts for enforcement notices and letters to be served. I'll deal with that in a second. Okay, and it does also seem to be there's been a particular case in relation to a fatality. Now I will be dealing with risk assessment and responsibility as we go through as well, so I'll pick that one up as we go through as well. So I think that's probably picked up most of the ones now. So if I start looking at the sort of the major legal framework from maybe a local authority point of view, there are several sections of the Building Act. Some of these overlap with other legislation as well. The main ones when we actually get to a dangerous building are Section 77 and Section 78. And again, which section is applied to the project, really it depends upon the extent of the danger and how imminent, if you like, that threat may be. But if we start looking at some of the bits and pieces there, defective premises can be dealt with by a local authority. If there is a defective premises or it's in a defective state, then the local authority can serve an abatement notice. Now, in most local authorities, this doesn't actually sit within the building control function because it is an issue about public amenity. So you can serve a notice. The owners have to comply with the terms of that notice within a specified time frame. And if they don't comply with that notice, the local authority may carry out the work and recover reasonable expenses for doing so from the person who's in default. But obviously there are issues in terms of serving notices. We have to make sure that we're serving them on the correct person. So normally part of the process involves establishing legally who owns the property, and that may mean serving actual questionnaires on occupants, so that we actually can make sure that when notices are served, they're served on the appropriate person. So that's the defective premises. When we start looking at something that might be slightly more dangerous, Section 77 of the Building Act deals with dangerous buildings. And I tend to feel that the best way to describe this is something with the potential to be dangerous. If it's immediately dangerous, if something is falling off or the wall is likely to collapse, that really is an immediate danger dealt with under Section 78 of the Building Act. Section 77 is about those situations that are going to become dangerous. Now, again, this lead to some issues, because quite often under you know, looking on a weekly basis to establish if there's any further deterioration. And again, this can cause a potential argument, conflict, if you like, because at some point there may be a tipping point between it being potentially dangerous and becoming dangerous, and there will then be a debate about what caused that to happen. So if we've got a building that is potentially dangerous, and it's either dangerous because it's actually falling apart or it's carrying loads that aren't suitable for the building, then the local authority can apply to the magistrate's order for magistrate's court for an order. The court can then make an order against the owner requiring them to remove the danger, and the owner can then choose either to carry out works to take the dangerous part of the building away or to demolish the building, or potentially to restrict the use until the matter is resolved. And to give an example from several years ago from an authority I was with, we actually had a situation where in the high street over a retail unit there was a nightclub, and because the type of music that was being played in the nightclub changed because trends change, it hit the natural resonant frequency of the building, and as a result the building physically started to shake itself to pieces. So the court order in this case actually restricted the club in terms of what music they could play, what frequency it was, so the building wasn't falling apart, and that had to be monitored going on a sort of a weekly basis to make sure that that order was complied with. But again with this, if the owner fails to comply with the order within the time frame that's stated on that, then the local authority can move in and do reasonable work and regain the expenses. But in all of these situations, the local authority needs to really be doing the minimum work to make the situation safe. Okay, so that's potentially dangerous. Section 78 is immediately dangerous buildings. This is where we turn up and there's an immediate danger to the public or to people around the building, and immediate action has to be taken. Now, as far as possible, the first step should always be to try and talk to the owner and get them to carry out work. And at this point, there will have to be a judgment call as to whether this is an immediate danger or whether it is something that could be dealt with more appropriately under Section 77 by serving an order on the occupants. So there has to be a judgment call. But if it is immediately dangerous, again, the local authority can move in and recover expense for any work needed to remove that immediate danger. Again, the owner or the occupier, if of any premises, not just the person involved, if they feel they've had some detriment or they've suffered damage as a result of what's been carried out, they can then appeal to the courts and ask for justification as to why the work was carried out using Section 78 for emergency measures. And if there wasn't suitable justification, seek compensation from the courts. So again, one of the key factors in deciding to take action under this section of the Building Act is to ensure that there is a clear need for the work and that it's recorded in a manner that will show later on that need. Now, actually, I think increasingly we will be looking at video evidence rather than photographs, because a lot of dangerous structures relate to actually bits of the structure moving in the weather conditions, which you won't get from a still photograph. So it is quite useful to make sure that we've got something in terms of video record as well. But we also have to make sure that however we record things, it's in a format that's going to be suitable for the courts to consider. So they will have to be satisfied that however it was originally recorded, there's a sort of a chain of evidence where that recording can't have been tampered with and altered in any way before it gets in front of the court. Okay, I'm just going to pause and see if there are any further questions at this point.
Yeah, hi Kevin.
So I'm just scrolling down. Yeah.
There's a few with regard to the section 77 and 78 letters and about the enforcement and whether it has to be awarded by the court for it to be enforceable.
In terms of the formal notices, obviously most local authorities will send letters in the first instance, quoting the legislation, advising of what may happen, and quite often those letters themselves as a less formal notice will be sufficient to get the owners to do the work. But fundamentally, in relation to section 77, if it gets to the stage where there needs to be a formal court order to force somebody to do it, that has to go through the magistrate's process. Quite often what will happen prior to that is local authorities will serve a formal letter or an informal notice which goes in the same manner. And that's important as well, because when you go to the court to get the court order under section 77, the court will want to see that the local authority have made every attempt to try and resolve this matter by other means. So most local authorities will operate a good enforcement policy and will actually deal with this by communication, by talking to owners, working with them, by sending letters before we actually formally get to a notice through the courts. But as the legislation is laid out, it needs to be a court order to force somebody to do that. When we're looking at section 78, because it is an immediate issue, there is no need to go to the court before you actually do the work. You can do the work there and then when you turn up and find the danger. But you do have to still do all of the rigorous recording and justification of why you've done it, because subsequently it could still end up in front of the courts with an owner seeking compensation. Okay.
There's one just popped in, Kevin, actually, about
yeah.
Would you recommend that you use a risk assessment matrix or formulas to determine whether you need to use the section 77 or 78?
Yes, I think in answer to should you use a risk assessment matrix, risk assessment is a critical part, and I'm going to touch on that in a moment in terms of how we actually deal with the project in itself. In terms of can we actually put a formal risk assessment to this, can we therefore judge the extent of the danger, if you like, on a risk assessment basis? Obviously some of the clear principles of risk assessment, things like how likely is something to happen, and should it happen, how severe are the consequences going to be, which are the basic principles of risk assessment. Yes, that's something that can be applied to a situation. The difficult call tends to be actually in terms of who is likely to be affected. There tends to be an element of, if the only person being affected is the occupant who knows full well about this issue, there tends to be, well, perhaps there isn't as much of a problem. We've told the occupant not to go near his garden wall, therefore it's his own fault. That doesn't really stack up in law, but yes, regardless of how you go about determining whether something is immediately dangerous or not, there is an element that what you are doing, even though it may not be written down, is a risk assessment. And one of the critical factors here is actually making sure that the individuals who are looking at this, the surveyors, the building engineers, the local authority building control team who are looking at dangerous structures, have sufficient knowledge and expertise and knowledge of construction of older buildings, because a lot of the dangerous structures occur on our older building stock, to appreciate the actual issues that may well be involved. And it can be a very difficult judgment call. And dangerous structures don't just occur because of bad weather. An awful lot of dangerous structures come about because something else is going on. On numerous occasions, building control are asked to go to the scene of a fire whilst it's still underway, because firefighters are asking regarding the stability of the remaining structure, whether it's suitable to deploy firefighters into a situation. And a snap decision has to be made there. And it's always better in that situation, particularly where lives could potentially be at risk, that you err on the side of caution in making these judgments. There tends to be, within the construction industry, a belief that if I can get in and do something quickly, then the fact it's dangerous isn't so much of an issue. We can't really take that approach with dangerous structures. Something could go wrong at any particular time. So yes, it is a risk assessment. Can you produce a definitive guide or a list, a checklist of people to use? Probably not. Okay, are there any other questions that have popped in, Kate?
I just want to pick up on one from Eric, actually, regarding that we tend to assume that the problem is a physical one in terms of the actual structure. Could a building be classed as dangerous if it has sort of faulty fire detection and alarm systems because it's dangerous but in a different way?
That wouldn't be covered by this legislation. A building that was dangerous to the occupants because of the way in which it's being used or a lack of fire precautions would generally be picked up under other legislation, either health and safety at work legislation or potentially under the regulatory reform order if it's a workplace and the fire precautions are inadequate. Where there is a loophole, if you like, is in the domestic sector, where there is no real control about how people use their premises. It would only move into the dangerous structure type situation if perhaps people started overloading floors or things of that sort, which you can sometimes get when people change the use of property slightly, or I have had situations where the sort of hoarders that you see on the television programs where they hang on to absolutely everything can eventually start overloading the floors with the sheer volume of material that's in the property. But yes, it has to be something relating to the actual failure of the structure, if you like.
Okay, thank you.
Okay.
And then can we just pick up on one other quick one, Kevin, sorry, regarding if it was a garden wall, is this a building control issue or is it just a civil issue if it's just a garden wall as such?
Theoretically, this legislation will extend to structures such as garden walls. Ordinarily, the simple approach there is to get the owners to sort it out. There will be potentially other issues, things like the Party Wall Act, if it's on a boundary, that sort of thing. There are obviously obligations. Garden walls, I would suggest, in terms of emergency action or how dangerous it may be, sort of fall into one of two categories. Either it's that dangerous that actually what it needs is pushing over straight away, or it's a question of restricting access to that area temporarily till it's sorted out. They are usually best left to the owners to resolve, but it may well be that if it's a few loose bricks on a garden wall, that the simplest approach is actually to remove those straight away. But theoretically, there is enough scope here to deal with things that are associated with the building that aren't necessarily the building themselves, where it wouldn't necessarily go as far as dealing with things like highways, which would fall under separate legislation again. Okay, if I move on slightly, because I think we'll cover some of the other bits and pieces as well as we go through. There is provision for local authorities to deal with ruinous and dilapidated buildings, neglected sites. Again, this doesn't tend to be a building control type issue, but there is the ability for the owners to be asked to execute works to remove rubbish from a site to protect the public amenity. This tends to be open to far more debate as to when is something detrimental to the neighbourhood. But again, there is a process here where notices can be served on the owner and the local authority can step in and carry out works if necessary. So in dealing with it, in dealing with the dangerous structure, there is a responsibility to the owner and the occupier of the building. There is a responsibility to the public and visitors to that building. And then there's also the personal responsibility of the person who's having to assess the danger. And there should be no expectation that in assessing the condition of a dangerous building, the surveyor is putting himself at risk to establish whether the building is safe or not. So there is a need in terms of personal responsibility to carry out a risk assessment. But as I say, that may be something you do in your head rather than on paper. But it can be useful to have just a sketch, an outline on paper of what I think the actual risk is, what's the likelihood of something happening, and if it does, what's the potential of somebody being injured, because that can form the basis of where you move with your next step of action, and it can also be part of the evidence that you'd have to then put through to a court later on should it end up in front of the courts. So there has to be an issue of the risk assessment. Now, it may well be, if you look at a picture such as the one on the slide in front of you, that yes, it's clearly in a very storey state as a building. There are a lot of loose tiles, there's cracked masonry, no indication of how long that building is going to remain standing. Looking at it on a day like today, a nice summer's day, very little wind, probably not a huge amount of risk. We could potentially just fence around the building, leave it there and get it dealt with later on. But should we suddenly have a storm tonight and high winds, those slates could be flying around the street. So there has to be an element of what's likely to happen as we go forward. But it is absolutely essential that the individual looking at this doesn't put themselves at risk in trying to make an assessment. So as far as possible, we would look at removing the risk. Now, there will be instances where that means going in and stripping roofs of slates. It may mean propping up of buildings, but it quite often will mean actually just fencing the building off and leaving it to its own devices, if you like. But everything has to be recorded and reasoned so that we can justify later on why we took the action we took, or perhaps why we didn't take any action at that stage. And some of the things you will consider will be things like the location. If you're in a city centre and there's a dangerous building and there are slates falling off a roof, that's going to be an issue to people going past the building. If you drive out into the countryside and there's a derelict barn in the middle of a field, it's potentially not causing the same risk to people round and about, so it could be dealt with in maybe a different way. But what we do have to look at is the risk to the occupants, the risk to the visitors and the public around the building, and also the rate at which things are changing. And if you think back to the slide about the insurance with the car and the wall, the normal question is, where's the danger? And quite often, whilst the car is still actually lodged in the wall, there isn't any danger. It's when you start to remove it and the wall starts to collapse that there's a dangerous situation occurring. So you have to look at not only what's it like now, but how is it likely to change in the future. And the difficulty with that is quite often it's difficult to establish how quickly it's changed in the past, because you tend to get called to look at these things in a state, and there isn't necessarily a history of how long it's been like that. And then you will have to not only look at those features, but look at the actual site and the conditions. So do we know that it's been in a poor condition for a long while? Has it been the result of damage? What caused the damage? Can we actually get safe access? What's the most appropriate way to actually deal with this? And then what additional equipment might I need to be actually deal with this dangerous situation? And again, there is generally a tendency for those dealing with dangerous buildings to take a few more risks in terms of removing some danger, so potentially removing the odd loose brick, which again, before we actually start to do any work, we should be considering the potential risk and the implications of what we might end up doing. So we do have to consider if the building is occupied, if we know the occupants, have we made them aware of what's going on. You can find an awful lot of derelict buildings where you may find squatters, vagrants, children, so we have to look at access arrangements and sealing buildings up. And quite often if you turn up to deal with something that's dangerous, you may find that the actual owner and the neighbour may well be not inclined to carry out work, or maybe already in a confrontational situation over whatever is occurring. So those sort of things have to be handled as well, and you have to consider the risk of the people involved as well, to those carrying out the work. And then you have to look at what is the appropriate action to take. Do you actually remove part of the building? Do you actually demolish part of it? Do we just restrict access? Can we close roads? And again, that will depend on other implications. There may be some situations where the best option would be to close the road, but practical considerations make that not a long-term solution. So again, there has to be a balance of what we do and how we move forward with it. And then there are other responsibilities. If as a surveyor you're carrying out your statutory role, then some of the CDM regulations in terms of health and safety won't necessarily apply. But once you start actually carrying out work or specifying how work is carried out, you will become a designer in terms of CDM and have responsibility in terms of health and safety to those carrying out the work and those using the premises after the work's been carried out. And increasingly what we see is where local authorities have designated contractors to deal with dangerous structure work, the speed of response is slowed from where perhaps it used to be more immediate, because the contractor, as his first stage under his responsibility under the CDM regulations, has to do a risk assessment before he can deploy people into the situation. So, you know, probably 10, 15, 20 years ago, if there were slates sat in a gutter that could potentially fall down, a contractor would turn up, put up a ladder and take them out. Now they have to be more aware of their responsibilities in terms of health and safety and would have to risk assess the most appropriate method of carrying out that work. But it is important from the surveyor's point of view to realise that they are instructing a contractor or giving direct instructions or indeed carrying out work themselves. They have to be aware of their responsibilities in terms of the CDM legislation. And as far as that legislation is concerned, the designer is anybody who feeds into that process. So as soon as you start specifying how work needs to be done, you may well become a designer. So it's quite often preferable to get a competent contractor in and just explain the extent of the danger and leave the process and the way in which they deal with it up to them, because they will then have to do their risk assessment to decide how best to deal with it. And then obviously we do end up with a huge range of extremes of conditions, and to be fair, there will be always situations where you're dealing with the aftermath of a dangerous structure. It wasn't necessarily foreseeable, it wasn't something that progressed to a state, and you do have to take a view. So a lot of the pictures in front of you there are sort of extreme conditions, collapses of buildings, extreme weather where trees fall onto buildings, and then the bottom right-hand corner, that's a collapse during construction process. But realistically, all of these things are potentially covered by the legislation. But there has to be as well an acknowledgement of resources. If you go back to the good old days of Michael Fish telling us there certainly wasn't going to be a gale, the following day there was absolutely no way any given local authority could have dealt with all of the damage that was occurring, because every other property along the road probably had tiles and slates falling off the roof or trees falling down. So it has to be proportional, and I suppose all you could argue in those cases is that because of the extreme weather conditions, there was a greater awareness amongst the public, and perhaps people were being a bit more careful. But you still have to take every step you possibly can to protect people. Right, Katie, have we got any more questions?
There's not really at this stage. There's quite a few things that I know you've already covered off. And I think there's a couple that what I might suggest is that we actually go back separately, because it's sort of like continuing on in terms of the questioning. What I would like to ask though is if anybody who is attending today has actually dealt with either an interesting dangerous structure or been involved in perhaps a high profile case, then we'd like to know, in the sense that, you know, there's always an opportunity to feature this as a case study, perhaps within Building Engineer or on our website. So drop me an email if you've got anything that you want to share with us and with other building engineers as to how you dealt with the situation. That would be really good information to share, I feel.
Yeah, I mean, that would definitely be useful from our perspective. I've just scrolled down through the questions that have come through as we've been going on today, and I think maybe the only one that I could perhaps touch on again is there is a question that says, if we start off monitoring something or dealing with something under Section 77 because it has the potential to become dangerous, can you at some point when it becomes worse then take action under Section 78? The answer to that is yes, It does become slightly more complicated if you're already in the legal process under Section 77, because obviously Section 77 says you are serving an order on the owner of the premises to put work right, and will give them time frame to do it. Now, in getting that order through the court, once we get to that stage of the process, you have to establish what's a reasonable time frame for them to put it right. And that may well also depend on things like what time of year is it. If we're likely to hit the autumn with high winds, then perhaps the time frame should be shorter if it's something that's likely to be affected by the climatic conditions. Although if something changed on site to make it significantly worse, you could move into Section 78. It is more complicated if you're already in the legal process for Section 77, because there will be a legal debate as to why you suddenly decided that you needed to take emergency action. You will have to justify why you did that. You will also have to justify why, if you'd set a time period under Section 77 to put it right, so maybe you'd given somebody 28 days, why had you not at that stage foreseen that within 28 days it may become more dangerous and need something doing immediately? So it is possible to upscale, but it has to be fully justified, and you will have to argue that case as to why you've suddenly decided to take the immediate action when we were already in a process looking at it some other way. Okay, what we will be doing is going fully through all of the major issues in terms of some of the questions that have popped up, and popping those up on our website. There is just one other point I wanted to comment on, which has popped up in terms of some of the questioning. Obviously this, if you like, is the legal framework from what the Building Act says, what local authorities' responsibility is. There are also obligations on householders. So if something goes wrong, if a chimney falls from a property and damages next door, if slates fall off the roof and damage the car next door, there is a civil liability alongside this as well. So there's a legal framework for dealing with the immediate danger, but there will also be civil claims and civil liabilities for any damage or injury caused as a result of one building or affecting somebody else, whether it's a neighbour or somebody visiting the property or just a passerby. So there will always be that level of responsibility as well. And it is worth just, obviously, when you're talking to owners, talking to clients, making sure that they have sufficient insurance cover to actually cover that level of responsibility as well, because that can end up being fairly significant. Okay, I don't think we've necessarily got any more questions or anything that's hugely different. So as I say, we'll put them together in the frequently asked questions. So I'm going to hand back to Katie to round up this webinar for today. Thank you.
Thank you very much, Kevin, and thank you for your time this morning. Again, I would like to apologise for the technical problems that we had this morning. We will be putting the recording of this available online later if you did miss any of it. And again, I can only apologise. The issues were purely at our end. It was due to our connection. And thank you for those of you who've been dropping me messages just to let me know when you've got all your sound back and what have you. Our next webinar is on Wednesday, the 22nd of July, and the subject for this one is means of escape. If you wish to join us, you can register via our website, follow the link and register in a similar way to which you did today. So again, I would like to thank you for joining us. Thank you for Kevin for sharing his knowledge with you this morning, and hope to see you online again soon. You can record 1 hour CPD, and for members, you can log into the website and add this to your record. Thank you very much. See you again soon.